to be here for 2 of the 4 panels. What I heard was incredibly engaging and thought-provoking. Clearly some ideas about which reasonable minds can disagree. If we can agree on one thing today, it has to be, I think that Professor Teeter and the Utah Law Review did a spectacular job of putting together the program today, so please help me to thank him and all the panelists. But of course we're not finished. It's our great pleasure to have as our keynote speaker former U.S. Senator from New Mexico, Jeff Bingaman. Senator Bingaman has an undergraduate degree from Harvard, his law degree from Stanford. He was the elected Attorney General of the state of New Mexico and then elected to the U.S. Senate, where he served from 1982 to 2013. Among his many roles and accomplishments in the Senate, he twice served as chair of the Senate Energy and Natural Resources Committee. I just told him that I actually testified in front of his committee a number of times, something that I remember well, and of course he, the thousands of witnesses he had before him would not possibly have remembered. He played a major role in the enactment of the Energy Policy Act of 2005 and the Energy Security Act of 2007, which led to an increase in vehicle fuel economy, enhanced production of biofuels, and increased energy efficiency. I hope the senator will take note that the building that we're building next door is a LEED Platinum Law School building, one of 2 in the country, which will exceed energy reduction code requirements by 50%. So we are moving in the direction that you advocated for in the Senate. He also served on the Senate Finance Committee, the Health, Education, Labor, and Pensions Committee, and the Joint Economic Committee. In April of this year, after leaving the Senate, Senator Bingaman joined the Steyer-Taylor Center for Energy Policy and Finance at Stanford Law School. Clearly, there are a few people who know more about the issues that we've been talking about today than Jeff Bingaman, and we're very honored to welcome him as our keynote speaker.
Well, thank you very much. After listening to all these panelists, I think that clearly there are at least 16 who know a lot more about these issues than I do, but I'm glad to be here. And I also thank the Law Review and Michael for including me. This is a very informative day, and I've learned a lot, and hope all of you have as well. The subject governing the United States in 2020 sort of caught my eye. I guess I'm not exactly sure why 2020 was chosen. First thing that came to my mind was the famous statement that Yogi Berra's got. There it is, right there. It's tough to make predictions especially about the future. So I can't pretend to tell you what things are going to be in 2020. I do think it's useful to do what we've been doing most of today, and that is reviewing the current problems that we've got and trying to identify solutions to those. Clearly, much of what I'm going to say has already been mentioned by other speakers, but I hope that I can at least add a few things to it and perhaps restructure the discussion a little bit. In a democracy, at least from my perspective, an essential element for effective government is maintaining a certain level of consensus, both in the public but also among those who are supposed to lead the country. And that's been a challenge for us, frankly. These are 3 areas in which I think we need to try to have and maintain some level of consensus. What are the challenges we're trying to address as a nation? Second, what role should the government play in that process? And third, what are the rules and procedures that we should follow in resolving disagreements? Because we're obviously going to have disagreements about what we're trying to do, about the role of government, about pretty much all aspects of trying to make progress. Unfortunately, in recent years, the last couple of decades at least, we've seen our institutions evolve in ways that make it more difficult to achieve this necessary level of consensus on any of these issues. I want to discuss some of the factors that I think have impeded our ability to achieve consensus. And as I say, some of these have been mentioned by other speakers, particularly in the first panel this morning. Simply put, obstacles to achieving consensus have proliferated during these last two decades. I was on the Armed Services Committee for 20 years. I know Professor Roberts was counsel to the Armed Services Committee there in the Senate prior to my being there. And if this were a Pentagon briefing, instead of talking about obstacles to achieving political consensus, we would be talking about OTACs and the proliferation of OTACs. But however you choose to refer to the problem, I think some of these obstacles can be identified in very concrete terms, and hopefully solutions can be found. First, we should define what institutions we're talking about, and we could talk about a lot of them today. I'm just going to talk about two. But the process of elections, campaigns and elections is one of the two I'm going to talk about, and secondly, the functioning of Congress. As I say, we could talk about other whole categories, the role of the media in injecting obstacles, the role of large sums of money in our political process is another factor. But let me first talk about some of these obstacles to achieving consensus that have arisen in our system of elections. I'll talk about three of these. First, the straitjacketing of those who choose to run for Congress or for office of any kind, really. Second, in some states, the structuring of the nominating process to limit the participation both of candidates and of voters. And third, the gerrymandering of congressional districts. And I know Professor Sinclair said that is not a major part of the problem, and maybe not. But from my perspective, it is an issue, and I'll try to explain why. First, let me talk about this straitjacketing of those who would run for office. What I mean by this is that in order to win the nomination for a seat in the Congress today, candidates are, in some cases, required to commit as to how they're going to vote if elected, and not just in general terms. They're required to make very specific commitments, reduce those commitments to written pledges that are then brought back to remind them that they have been signed. The most obvious example of this is one that you're probably familiar with, the Taxpayer Protection Pledge. That pledge says that candidates, once elected, will oppose any increase in income tax rates, and which is fairly easy to understand and general in its terms, but also it says that such candidates willing to sign this will oppose, quote, any net reduction or elimination of deductions or credits unless matched dollar for dollar by further reducing tax rates. Now that's a pretty specific pledge. There are 218 of the current Republican members of the House who have signed it. There are 39 Republican senators who have signed it. I think there's one Democrat who signed it in the House as well. As I said previously, I think I said previously that candidates are required to sign this pledge. They're not required to, but I would say that in many congressional districts, it is difficult for a Republican to win his or her party's nomination unless they've signed this pledge. I think it is something of a litmus test. So when we see the current budget negotiations in the Congress going nowhere, which is where I predict they will go, although I may be proven wrong next week, we'll see. Some of the problems, in my view, trace back to the straitjacketing of candidates before they were even elected. The elusive grand bargain, which we've been hearing about now for several years, this is between President Obama and Speaker Boehner. They tried to successfully achieve a grand bargain where Democrats would support reductions in entitlements. I believe the president actually put some proposed reductions in entitlements on the table for consideration and made it public. So it's not in any way a secret negotiation. But those reductions in entitlements were in exchange for Republicans being willing to support increased revenues from the closing of tax loopholes. That grand bargain, of course, would violate the pledge. And the pledge also makes it more difficult to get agreement on annual budgets and to pass annual appropriations bills. We wind up operating as we are today in Washington on a 2 or 3 month continuing resolution. And part of that, as I say, is because we can't get agreement on these basic budgetary issues, and partly we cannot because of this pledge. This is not the only pledge that members of Congress have signed. In my view, it is the most important pledge because it has done the most to derail the normal budgeting process that previous Congresses have followed. Of course, on the Democratic side, there are also pledges that members are urged to sign. In some cases, they do sign them. But in the case of those pledges, there is less pressure on Democrats, at least in my experience, to sign them. And they know, or at least most of them believe, that there are fewer consequences from their not signing the pledge, and even there are fewer consequences if they choose to sign the pledge and then determine that at a later date they have to violate it. So that's the pledge issue. The second, going back to my list here, the second issue I wanted to mention in the election and campaign and election process is this obstacle to achieving consensus that results from the restrictive nominating process that exists in some states. There are two aspects to this. One aspect is the limiting of which candidates can appear on the primary ballot, because, of course, in some states, Utah, I think it's fair to say, is one of those. In some states, winning the primary is pretty much tantamount to election if you're running for statewide office. And there are other states where being a Democrat, winning the Democratic primary is tantamount to winning an election. But so one aspect of the problem is limiting the candidates that can appear on the primary ballot. The other is limiting the voters who are able to vote in the primary. The first of these problems, as I indicate, is known here in Utah. Candidates whose names appear on the ballot in a party's primary are chosen here by a party caucus. The effect of this, at least in some cases, is to prevent candidates who have broad support within the party, the rank and file of the party, from actually getting their name on the ballot. I'm aware there are efforts underway to get that changed in Utah, and I commend the folks who are trying to do that. I'm not a resident of this state. If I were, I would be trying to support that effort. But the second aspect of the problem is not just a problem here in Utah. We have it in my own state and in many states. That is that many of the registered voters are prevented from voting in the primary election, and that's particularly a significant issue where the primary election is the determining election because of the voting registration in the state overall. Here I'm talking about voters who are registered as independents. In my state, in most states, the percentage of voters who have registered as independents has been growing each year for many years, and I see no reason to think that's going to change. One reform which would help enfranchise more voters is to allow those independents to vote in a primary election. They can choose which one to vote in. This would tend to ensure that the winning candidate in a primary has been chosen by a larger and a more diverse group of voters than is currently the case. To my mind, this would be a benefit to our election process. So the The third obstacle that I wanted to talk about, it does relate to gerrymandering of congressional districts. The problem of gerrymandering of congressional districts has been recognized for a long time. It's been with us for a long time. In my view, it makes consensus building in Washington more difficult in two somewhat distinct ways. And the first way it makes consensus building difficult is that it results in people being elected who have more extreme views than the mainstream of the state from which they hail. The second way in which I think it is an obstacle in our process and makes consensus building more difficult is that it entrenches incumbents. The way our founding fathers designed our government, the ultimate solution to gridlock, we've all been talking about gridlock in Washington, the ultimate solution that the founding fathers had for a problem of gridlock in Washington was intended to be the next election. That may be one reason they gave the House of Representatives a 2-year term. If the members of Congress are all gerrymandered into safe districts, that solution does not work. And the old threat that you can throw the rascals out is a hollow threat in those circumstances, and to a large extent, it's a hollow threat today. So those are three obstacles to achieving consensus that I think relate to our election process, to our campaigns and election process. An even more obvious place that we can find obstacles to achieving consensus is in the functioning of the Congress itself. And one way to describe what's happened in Congress in the last 2 decades is to say that we have lost the consensus in Congress on our rules of engagement. Now, this is, of course, a military term, rules of engagement. The dictionary says rules of engagement are directives issued by a military authority controlling the use and degree of force, especially specifying circumstances and limitations for engaging in combat. You might ask, what does a term describing conditions for combat have to do with the functioning of the Congress? I'd refer you to von Clausewitz's famous statement that war is merely the continuation of politics by other means. I think he had some insight. So if in the past there have been rules of engagement, or at least maybe more appropriately call them shared understandings that have been adhered to in the Congress, what are those? And if those shared understandings helped us to resolve disputes, can we define what they were? I would list 3 that I think would qualify as shared understandings. You can discuss them as shared understandings or as additional obstacles, but I think there was a shared understanding that both parties would have a responsibility to maintain a functioning government, and I'll go through some more detail as to why I think that's the case. Second, I think there was a shared understanding in the Congress, I felt there was when I arrived there at least, that Congress would ensure that the government would honor its legally binding obligations. And third, in the Senate specifically, there was a shared understanding that the right to filibuster and to put holes on nominations would be used sparingly. Unfortunately, it's clear to me at least that to a large extent each of these shared understandings has been discarded. The result in each case is a new obstacle to achieving consensus. So let me go through each of these a little bit. First, the understanding that both parties have a responsibility to maintain a functioning government. It's no secret that in recent years, Congress has had difficulty enacting appropriations bills on time. That's an understatement. To deal with this reality, the normal practice has been to enact short-term spending bills or continuing resolutions to maintain the funding of government at current levels while the negotiations on a longer-term spending bill continues. Unfortunately, and that continued for more than a decade after I had come to the Congress in January of 1983. Unfortunately, in 1995, that normal practice of passing continuing resolutions or short-term spending bills was abandoned. That year, Speaker Gingrich determined that by refusing to fund the government, he could gain leverage in his negotiations with President Clinton. He made a statement at the time that I felt was quite telling. Here it is. If you're going to operate with his, that is the president's, a veto being the ultimate trump, you have to operate within a very narrow range of change. So you had to find a trump to match his trump, and the right not to pass money bills is the only trump that is equally strong. So that was the rationale that he used at the time of the shutdown at the end of 95 and the beginning of 96. I personally have difficulty believing that the Founding Fathers intended that in disputes with Congress where the President had vetoed a bill and the Congress was unable to muster the 2/3 in both houses to override that veto, Congress could still get the upper hand by having a majority of one house choose to stop funding the government. Didn't make any sense to me that that would be an appropriate interpretation of the Constitution. Nevertheless, that was the rationale used by the Speaker to force the government shutdowns at the end of 95 and the beginning of 96. Last month, we saw the same tactic used again. This time, the policy dispute was whether the administration should be allowed to implement the Affordable Care Act, which the President, of course, signed 3.5 years ago. The travails of trying to implement that act, I'm sure, will be the subject for another symposium down the road, and probably jointly with the computer science department here at the university, I don't know. But this time, we all know that the refusal to fund the government continued for 16 days. It seems clear to me that this willingness in the Congress to shut the government to achieve an advantage in negotiations with the President on policy differences is clearly an obstacle to achieving consensus. We'll learn soon how big an obstacle it is, since, of course, the current provisions that were enacted after the 16-day shutdown only maintain funding for the government until January 15. So we will have another episode. Second shared understanding, and maybe I should go back to the shared understandings here, relate to the statutory debt ceiling. I believe the United States is somewhat unique, and some of you who are real experts at political science would be able to tell me this, but we're somewhat unique in even having a statutory limit on debt. The more logical approach is to recognize that the amount of borrowing that a country is required to do or engage in is a direct result of the tax policies and the spending policies that Congress enacts. If Congress fails to raise enough revenue or Congress spends too much, then the Secretary of Treasury has no alternative except to borrow to meet the government's obligations. So refusing to allow that borrowing forces a default on the very obligations that Congress itself has put into law. I served in the Senate for 30 years, from '83 until January of this year. During the first 28 of those 30 years, the taxing and spending of the federal government resulted in substantial increases in the national debt. We did have a period there, which you'll all recall, where we got to a balanced budget for a few years. And that was the first time in about 40 years that had happened. But that was short-lived, as it turned out. Congress, accordingly, since we were running up debt, Congress was called upon numerous times to raise the statutory cap on the amount that the Secretary of the Treasury was allowed to borrow. On those occasions when the debt ceiling needed to be raised, there were always speeches, and I gave some of those speeches, denouncing whoever happened to be president, at the time for not pursuing a more responsible fiscal policy. There were always protest votes cast against the increase in the debt ceiling. But the reality was that the leadership of both of the major parties in the Congress knew that refusing to raise the debt limit, thereby causing the Department of Treasury to default on government obligations, was really not an option. And that shared understanding that it was really not an option appeared to me to change, and appeared to many people to change, in August of 2011. That was the first time that a threat to deny the Secretary of Treasury the authority he needed was seen by observers of the Congress as a credible threat. As we all know, the default did not occur in 2011, but the threat of default resulted in a downgrading of our credit rating. It also resulted in the current sequestration that we are struggling with today. And that's a whole other subject for discussion as to how we got from there to sequestration, but there is a direct line. Last month, we saw another of these references, and again, Professor Sinclair talked about the Perils of Pauline crisis, and that's exactly what many of us referred to it as during the debate in the Senate in 2011. Once again, world financial markets reacted adversely to what they saw as a manufactured financial crisis in the Congress's unwillingness to go ahead and agree to an increase in the debt ceiling. Again, it seems clear to me that repeated use of the threat that the government will default on its obligations is another serious obstacle that imperils our ability to maintain an effective government. This issue, of course, is also timely, just as the issue of shutting down the government is timely, because in this case, the law the President signed on the 17th of October extends the debt ceiling until February 7. So we have the issue coming back very quickly. The final example I wanted to talk about here is the issue that comes to a head in the Senate, and that is what I consider the abuse of the right to filibuster, which is currently in vogue, and also the abuse of the right to put holds on nominees. And we've had quite a bit of discussion about that. Professor Roberts talked about the issue of holds in particular. The ability under Senate rules to delay and obstruct the passage of particular legislation by using a filibuster has been recognized and has been used for many decades. However, the use of the filibuster during most of that time was reserved for particularly controversial legislation or particularly controversial nominees. Now that general approach has been changed and abandoned, and the norm is that you need 60 votes to do much of the routine business of the Senate today. Holds on presidential nominees are also a major obstacle to the proper functioning of government. Holds on the nomination of judges as well. Judge Murphy pointed out the problems with regard to judicial nominees. In my view, this expanded use of the filibuster and the ability to put a hold on an individual or individual nominee, again, are significant obstacles to achieving an effective government and maintaining an effective government in Washington. So let me give you a few recommendations. I don't have solutions to all of these problems, but I think there may be some that we could take on. And pledges, first of all, going back to the list of problems with our elections and campaigns. In our elections, I think it's important that we recognize candidates and support candidates who pledge to uphold the Constitution once they're elected, but who refuse to sign written and detailed pledges as to how they're going to vote on other matters. It seems to me that if we're going to have a representative form of government, people need to go to Washington with some ability to deal with the reality that they're faced with once they are in office. On the issue of access to primary elections, we need to change state laws to ensure that candidates in a primary election who have broad support from rank and file party members can gain access to the ballot. And we also, in my view, need to change state laws to allow independent voters to participate in primaries. I'm hoping that'll happen in my own state. Gerrymandering. I would myself like to see us support state ballot initiatives and constitutional amendments where necessary to establish nonpartisan commissions to draw lines for congressional districts. I think taking this power away from state legislatures would make a lot of sense, and I think there's a long record of abuse in this area that would justify that. In the case of obstacles to achieving consensus in the Congress itself, I'd suggest that on maintaining a functioning government, I think the only real solution is to try to question candidates who offer themselves to be members of Congress, either in the House or in the Senate, to determine if they will vote to maintain a functioning government, regardless of the nature of the disagreement that is in vogue, and also regardless of who controls, which party controls the Congress, which party controls the presidency. Same thing with government, the paying of the government's bills. I think candidates need to be questioned about their commitment to ensuring that the government continues to honor its legally incurred obligations. I think our ability to maintain a strong economy depends on that. Filibusters and holes in the Senate, candidates for the U.S. Senate need to be made to understand that regardless of their party affiliation and regardless of which party controls the Senate, they have some obligation to allow the Senate to consider legislation and to consider nominations in all but the most objectionable cases. We have the procedure in place today where not only do you have to get cloture, that is 60 votes, in order to proceed to you've got to get it to pass a bill, but you've also got to get it to proceed to a bill or to proceed to a nomination, and that needs to change. The proposal that's in the Senate to require filibusters to be talking filibusters is a reform that I supported when I was there. Senator Merkley and Senator Tom Udall from my state have proposed this. I hope that this can become law as well. This can become a change in the procedures in the Senate. And holes need to return to their original intent, in my view. The original intent of allowing senators, there's nothing in the rules of the Senate that allows senators to put holes on nominees. It's just the practice that's developed. And the practice has started by saying if you have an objection to a particular nominee, you can put a hold on that person, and thereby you'll be notified when we're bringing it up for a vote, so you can come and object, and you can come and give a speech, and you can filibuster if you want to, but the hold as such was not an indication that the Senate would not proceed to consider the nomination. That's changed to a circumstance where holes have now morphed into actual filibusters, and the majority leader has determined that he has no choice but to assume that if a hold has been put on a nominee, that is going to be followed up by a filibuster if he tries to proceed to that nominee. And so a hold has a very substantial impact, which it was never intended to. We need to return to the original idea of holds, allow senators to notify their particular cloakrooms as to when they have concerns about a particular nominee, but not to guarantee anybody that the Senate will not proceed to bring that person up for a vote and proceed to affirm them or defeat them. So when we look ahead to 2020, I don't know better than any of you exactly how all of these issues that currently plague us will stand in 2020. But to me, the effectiveness of our government in 2020 will depend to a large extent on how well we have overcome some of the obstacles that I've mentioned. In the final analysis, of course, in our system of government, this can only happen through the efforts of an informed and engaged electorate. To maintain a strong and prosperous country, we need a well-functioning government, in my view. We also, of course, need a well-functioning private sector. I think Professor Menifee-Libby made the point that the two need to work together, that we don't get much done in our system of government and our economy without the two working together. That will require men and women in government who understand the importance of resolving disputes and achieving consensus. I hope that many of the current students here in the law school will aspire to one day serve in government in an elected position, in an appointed position. I think this is important work. All cynicism aside, and it's hard to put cynicism aside when you're discussing Washington these days, but all cynicism aside, the work of a well-functioning government truly is the work of the people, and it's very important that we find a way to achieve this well-functioning government. Thank you very much.
So as you'll note in the program, we allotted an hour and 15 minutes for Senator Bingaman to speak. We didn't know if he was going to be filibustering today or not. Had he given us his remarks in advance, we would have known. We didn't need to budget that amount of time for him, but because we did, we have a few moments for questions if there are any. But I will remind people that questions end with a question mark. So please keep that in mind as well. Yeah.
Senator, I was reading about how long you served in New Mexico as the junior senator to Pete Dominici, if I say that right. And you know, very interesting to me that the state has two senators from different parties. Not something we do a lot here in Utah, actually. I was just wondering, in terms of consensus and those kinds of things, you might tell us a little bit about your experience serving with the Republican senators for so long.
Well, it's not unusual in the history of New Mexico to have senators from both parties. 26 of the years that I served, 26 of the 30 years that I served in the Senate, Pete Dominici was also in the Senate. He was the senior senator. And I would say that we're friends. We worked well together on issues that particularly affected New Mexico. And frankly, we canceled each other's votes on a lot of issues of a national nature, where he was pretty much down the line with the Republican position, and I was pretty much down the line with the Democratic position. Yes.
I wasn't able to be here in the morning, and I don't know if it came up, but I've heard in political science circles proposals for a 4-year House term, or somehow that part of what's problematic is the very short terms and perpetual campaigning. And I wonder what you think of that.
Well, I didn't hear it discussed this morning, but some of the folks who study this on a full-time basis probably have more of an opinion than I do. My own view is that it would be an improvement. 4-year terms would be better than 2-year terms, because there is so much time that has to be committed to raising the money to run a campaign. And if you could lessen that even to some extent, that would be worthwhile. That is a benefit of being in the Senate, is you don't, at least from a smaller state like New Mexico, you don't have to start raising money the day after you're elected. You have a 6-year term, and you can pretty much put that off for a few years. I think in the House, most members are in what is generally referred to as a permanent campaign.
Can the Senate make people threatening to filibuster actually do it? And if so, why don't you do it?
Well, the problem is that the rules as they currently, and this is getting way down into the weeds of how Senate procedure works. But under Senate procedure, anyone who is talking about an issue, if you're out there, you can come to the floor and say, I object to Joe Blow being the Deputy Secretary of Interior. And then you can say, Mr. President, I suggest the absence of a quorum. That puts the Senate into a quorum call, and the only way you get out of that quorum call is for the majority leader to come to the floor and bring 50 senators to the floor and establish to the satisfaction of the presiding officer and the parliamentarian that, in fact, there is a quorum present. And so it's hard to explain to folks that it's not really the filibuster that's the problem. It's this ability to put the Senate into a quorum call, which is a way that people can avoid having to do a talking filibuster. And that's what happens on a pretty regular basis.
I would push this point, but there's so many different views. You could limit, these are all Senate rules, right? So
Right,
you could
and
change the rules so that you would have to talk for so long before you could call for the quorum, et cetera.
Yeah, well, the Merkley-Udall proposal says that after a certain period of debate, you can't put in a quorum call. You got to keep talking. And there is no ability to interrupt the debate. You can continue to filibuster as long as you have the strength to do so, but you cannot put in a quorum call and thereby shift the burden to those who are of the other position that want to go ahead and get the issue brought up.
So that's in the works.
Well, the proposal was there, and it has not yet been brought up for a vote in the Senate, but I've supported it. I supported it when I was there, and there's still discussion that Senator Reid might be persuaded that he would have to support it as well. Yes?
So we've spent most of the day thinking about various proposals or throwing up our hands, but when we do say proposals, they require a lot of kind of legal work, constitutional amendments, statutory reform, change in judicial doctrine. How much, so one answer, but there might not be, one response is civility could improve a lot of this, and you've alluded to it in your remarks, that if we wouldn't have to change Senate rules, if people acted more cordial to one another, recognize we're in a shared enterprise. Is there any steps we could take without kind of institutional reform? What kind of things that you've seen that have gone the right way and the wrong way about engendering civility within our public leadership, especially the elected leadership, that could kind of we don't have to go through such pains. We don't have to criticize our system if both the electorate and the elected officials treated each other better.
Well, in the Senate, at least in my experience, people are very civil, and people get along reasonably well across party lines. And I'm good friends with quite a few of those folks that are on the other end of the political spectrum from me. And I think that's true of quite a few Democratic senators and Republican senators as well. And there have been efforts made within the Senate to do what you're talking about. Senator Schumer and Lamar Alexander from Tennessee have, had a initiative in the last Congress. I'm not sure if they continued it in this Congress, but I assume they probably did, to basically get senators from both parties together to talk about issues at a breakfast once a week or once every couple of weeks, and it would be. We would have somebody there to make a presentation on some proposal that he or she wanted to have considered in the Senate, and then we would have a chance to talk to them. And that kind of thing does some good. I think it's useful. So I don't think it's lack of civility that's the problem. It's not personal animosity that is causing the inability to reach consensus. It's the fact that people have committed themselves and feel like they are obligated to stick with positions that their constituents are demanding they stick with. That's my view.
Senator, it occurs to me that there's one area of consensus between both parties, and that's that nobody wants to invoke the nuclear option and change the filibuster rule by either a parliamentary motion or some kind of simple majority vote. And it occurs to me one reason that might be is because each party thinks they could be a minority in the next session. So that's in some ways a kind of constitutional consensus almost. Do you think that somebody should invoke the nuclear option because we've reached the point where the bicameral system can't function effectively with a 60-vote rule for doing business, that we should actually just dispense with the filibuster in a very broad swath of cases?
Well, I think dispensing with the filibuster in some categories, for example, eliminating a filibuster when you're trying to proceed to a consideration of a bill or proceed to consideration of a nominee, I think that should be done. And if the only way we can do that is through some kind of invoking of the nuclear option or something, then I would favor trying to do that. I think most of the people who I've talked to about it believe that if the Senate goes ahead at the beginning of a new Congress, it can go ahead and write its own rules by majority vote. It doesn't have to invoke any nuclear option. It's only the idea of a nuclear option where you basically change what the parliamentarian tells you the rules are. I mean, by majority vote, which you can always do. That only comes into play if you try to do it after you have a set of rules in place, because the rules themselves say you've got to have 2/3 vote to change the rules. So I think the right way to do it, I don't know how they're going to get through the rest of this Congress, but the right way to do it is at the beginning of the next Congress, go ahead and instead of continuing with the rules of the previous Congress, adopt a set of rules that cordons out certain things and says these are not issues and procedures that can be filibustered.
And Senator, do you think they'll do that?
Well, there was a lot of pressure on Senator Reid to do that at the beginning of this last Congress, and he chose not to. He thought he had some arrangement with Senator McConnell that the problem was going to be largely resolved. I think he's now persuaded that agreement wasn't as he thought. So he may decide to do it at the beginning of the next Congress. I just don't know. Thank you all very much.
So I want to wrap up today's symposium, of course, by thanking everyone for coming here today, in particular Senator Bingaman and our panelists from earlier today. Dean Adler opened this symposium by referencing some calls to scrap the whole Constitution because the system is run so far off course, and he expressed the hope that we could address those problems without doing away with our Constitution. And I share that hope, and in fact, actually at lunch today, students said, when is the hope part of the message going to be coming into this? And I don't think this is quite what she meant, but I hope that that's true as well. I share that desire. In fact, this whole symposium is built around the idea that we can do some fixing without having to scrap the entire constitutional structure and system. And I think that the important place to begin is with discussions like these today. So I hope that we can continue these forms of discussions by focusing not just on the problems, but also the solutions. And I also hope we've all heard about hindsight is 2020. I hope today some panelists demonstrated that maybe some foresight can be 2020 as well, and that by 2020 we have a little bit more functioning government. So thank you very much for attending today, and I look forward to talking with you out there. Thank you.